All right, party people, welcome to yet another episode of Law and Candor, the podcast wholly devoted to pursuing the legal technology revolution. I am Bill, and I am here with my co-host Rob, as always, and we are excited to have you today. Today, we're getting strategic about review and data. We hear a lot about organizations struggling with their data volumes and caseloads, and not enough about solutions, frankly. So we're talking with Jason Rylander of Axinn, who manages huge matters, a lot of HSR work, and we're going to talk to him about techniques for unifying matters via repurposing work product, and finding out how you do that. When that opportunity presents itself, and what it means to the organization that you're representing as counsel when you can significantly use work product and different technology, different pieces of work product from a prior case, and use it in a cross matter for your future case. It's an interesting conversation. I think you'll enjoy it. Before we get to that, however, we want to bring you some sightings of radical brilliance. This is the part of the program, as you may know, where we bring to you the latest and greatest of news of noteworthy innovation and acts of sheer genius. Today, we are talking about a law firm that only works on artificial intelligence. And the topic, it's a short article, but it caught our attention because they only work on artificial intelligence. And that's what got us into it.
Yeah, this is an article that appeared in Fortune. Why this law firm only works on artificial intelligence is the name. And of course, I guess, Bill, it was just a matter of time, right? Until you had a law firm that would specialize in this. And at first I was a tiny bit skeptical about it. But then when you think about it, companies are making big bets on AI. And as we've talked in other sightings, there are risks associated with this. There's bias, there's other things. And at some point, you're going to have your legal team analyze that risk, help you make decisions. But the problem is, most lawyers don't really understand AI, and most data scientists don't really understand lawyers. And how do you bridge that gap?
Yeah, and if you have a firm that is concentrating in this area, as their sole practice is in this area, I'm sure there's plenty of clients out there they could work with. It'll be interesting to see if big firms start to develop this practice within their firm, not as the sole focus of the firm, but as an individual practice. It'd be interesting to see if a big firm just buys this practice because they're getting a lot of clients that want to just discuss AI. But I think the firm makes a good point in that, oftentimes lawyers and AI technologists or data scientists don't necessarily communicate well with each other. Lawyers are, they see the data scientist as someone who's serving them to get them to their most important data quicker, faster, better, more efficiently, and cheaper. And the legal technology, the AI or data scientist is often saying it's not that easy. Here's the process. Here's how we're going to do it. If you could find a way to bridge that gap so they could talk to each other, it's pretty valuable service to provide.
Yeah, for sure. And there definitely is, this is something that we kind of deal with to some extent every day. There truly is a big gap between data science and law.
Well, it's kind of your job, right? This law firm is basically have a practice that is your job individually here.
Great article, interesting thing to think about. I think there definitely will be a lot of demand for this firm, and good to have something new to talk about.
Yeah, agreed. I think it's I think it'll be interesting to keep up with them. I actually wrote down the name of the firm. I'm going to keep up with them and see if they're in the news and who their clients are. It's interesting.
All right. Now on to our conversation with Jason Rylander, EDiscovery attorney at Axinn, master of large reviews, where we will be talking about and strategizing how to achieve cross-matter review discipline.
All right, so let's get into it. Jason, thank you for joining us. A couple of years ago, we changed it up in the podcast. Instead of asking somebody to give their title and the firm or company they worked for, which got incredibly boring, we want to kick it off with a question that has some of the best answers from our guests, and that is, how in the world did you get into electronic discovery? What path led you here? Because no one goes to high school and college hoping that they could be involved in electronic discovery to the extent that it even existed when we were in high school and college.
Right. Well, yeah, thanks for having me. I'm happy to be here. I was going to say that, I grew up a young boy in a small town in Texas, and every Halloween I dress up as an EDiscovery attorney. I don't think
no candy for you.
Yeah, the most unpopular costume in the town, oddly enough.
Right. I'd have a sign on me to explain it. Now, like a lot of people in EDiscovery, I, kind of backed into it, I guess you would say. I graduated law school in 2008 from NYU. Got a good job in Manhattan, and the layoff started. I was supposed to be in structured finance. That didn't really exist at the time anymore. So, along with a lot of other people, I was laid off after 6 months at the firm. So I was kind of out there looking for something to get back into the game with. And honestly, it was a Craigslist ad that I replied to.
Wow, interesting.
I was like, I need
love
to do
asking
something.
this question because that you might win for the best answer to this question. I got into EDiscovery off Craigslist. That might be the title of this episode.
I don't know if that's possible anymore, but you never know. But back in the day, that's how it happened. I didn't know what a doc review was, but that's what I was joining. And in a couple of months, they placed me at Cleary, not on a permanent basis, but kind of embedded at the
long
firm.
term, yeah.
Yeah. And then in a couple of months, they offered me a job as a staff attorney. So I kind of got thrown in the deep end right after I figured out what EDiscovery was and what, doc review was. I was tasked to start leading doc reviews there. So over the 5 years I was there, I gained quite a bit of experience on a variety of matters.
Yeah, the Craigslist is a great twist to what is sometimes, I think, a pretty familiar story for people in our industry that came in, had their first exposure through a document review. And I actually think it's something that's really helpful because, kind of in all of our DNA is this real hands-on experience with document reviews at some point, in our careers. Then we kind of progress into EDiscovery. And I think it's a great story. One thing that we've been speculating a lot here is that, with a new administration, in the antitrust world, there's always speculation about what will happen and, how that will impact, both enforcement, but then also on the merger review side. Just curious about, what you're seeing or hearing, are we expecting more second requests, more on the investigative side?
Right. And as a little more background, now I'm at Axinn, where I've been for almost 6 years. We do a lot of antitrust work, so I've gained some expertise in that area. But with COVID last year, there was, I know a general dip in activity, in M&A activity. Our firm was actually busier than ever last year, so we didn't notice that so much. And I know, it started ramping back up late last year and kind of continued through this year. As far as the new administration goes, I can't say it's affected us too much yet, but it will be interesting to see, how kind of the general increased scrutiny plays out over the next few years.
There's certainly flexing as if they're going to start. We're going to start seeing some stuff next year. I agree. So let's talk about the subject of this particular pod, which is doing a single matter doc review versus maybe doing something where you're repurposing work product and strategically. So for organizations encountering the same types of matters, let's say whether it's a litigation or investigations, what are some of the challenges? Let's focus first on single matter doc review. Some of the challenges and disadvantages of attacking it that way.
Right. And of course, that's, kind of the default. And sometimes the only way we can attack it if it's a client that doesn't have too many litigations to deal with or is not having to collect and review documents regularly. The challenges and the costs involved learning how to do a doc collection with a client that hasn't done it before can be time consuming and costly. There's a variety of, internal capabilities, of course, across different clients. So that can be a process in itself, just to learn the client's, internal architecture and get them up to speed on how the process will work.
Yeah, it does kind of feel like, in that single matter context, no matter how good, a firm is, or even sometimes how experienced the client is, there's always some degree of having to kind of reinvent the wheel.
Right.
Sometimes it's worse than others, but it's always kind of there, lingering.
That's right.
And just from our conversations before, we had a chance to visit a little bit. You've kind of been in the unique position of being able to do multiple matters with the same client. And, certainly there's advantages there. What are some of the, pros and cons that you see in that scenario?
Well, I guess it's mainly pros that I see in that scenario. The more you get to know a client and their data and their documents, the more efficiencies there are to be had, and that can be simply using the same reviewers on each matter so that they get to know the client's documents. But of course, there's plenty of technology we can leverage to increase efficiencies there as well.
Yeah, it's like every document review is a little bit different, but I think one theme that we see is the privilege review portion tends to be the most expensive and sometimes the most time consuming. Sometimes has the biggest impact on timing. When it comes to privilege specifically, what are some of the benefits that you've seen when you attack that in the context of a cross matter approach? Right.
Especially with some artificial intelligence tools that are getting better at detecting privilege. The more you feed the tool, the better it gets, and the more it gets to know a specific organization's privilege, people, and dynamics. So that can be very helpful, especially when you're dealing with large bodies of data with a client that may be very active in the M&A space.
It's interesting. So time and cost, right, associated with priv review is greatly impacted now by the AI we're seeing. So let's talk about the process of it all. So what is the actual strategy? What is the process you go through when you're going to repurpose data, and what are some of the strategies in identifying not just that you're going to do it from a macro perspective, but the specific either work product, or like you mentioned before, it's not just work product. It could also be using the same reviewers because there's a level of familiarity. So what's the actual process once you've identified, we're doing another, let's use an HSR as an example. We're doing another HSR for company ABC. We just did one for them 6 months ago. What is it that you start to cross-reference in your head that you might be able to repurpose and knowing that it'll save time and money, which are two huge components of an HSR especially?
Ideally you have the benefit of foresight, and you know that the client's going to have a similar matter coming up, but more often you're faced with having to look backwards and see if something you've already done might be able to be repurposed. An HSR is a good example. We currently have a client that has had a couple of HSRs recently, and a lot of times in these cases you're dealing with the same custodians. The deal teams are largely the same. So instead of going back and recollecting the same data over and over, if you already have it, of course, that's great. You can reuse it and just collect the delta. If you have the benefit of foresight, you can make sure that you keep it and preserve it so you can use it the next time. Of course, you don't want to keep data hanging around longer than you need to for no good reason. But of course, if you have a good reason to, then it can definitely pay off.
One of the hard things about being an attorney, and especially I think an e-discovery attorney, is that sometimes you're giving bad news to clients about, budgets or timing. But when you have a cross-matter scenario, it seems like that's kind of one of the times you can actually give good news to a client. And how's that been for you, and how do you typically approach that?
Right. It is good news to give a client that you don't have to do a full collection again. And if you can explain the efficiencies that you're implementing, all the better. Whether they fully understand the details or not, at least they see that you're trying to do things as efficiently as possible.
So let's talk about that a little bit further, though. So let's talk about the situation you said that doesn't happen nearly as often. But if you do have the benefit of foresight and there's a second one coming, Would you encourage the client to hold on and maybe host data just a little bit longer than they naturally would if they didn't have that second one coming, just so you can reap all these benefits? And so you're almost pitching this proactively before they even pulled and refiled the second time for the second project. Do you ever approach them there and say, look, here are the benefits that we're going to see and the ROI, and hopefully they get it, and then they're willing to invest by keeping the data up maybe months longer, obviously not years, but months longer than they ordinarily would have, because they see these benefits. Have you had the occasion to do that? And if not, one was coming up, how would you approach that with the client?
Yeah, I think it really depends on, each case. Each scenario is different. Not to dodge the question, but it really is, fact specific. But definitely, if we're able to see the scenario, coming where we could repurpose data, then we would definitely approach the client and explain it. And it's not that difficult to put together a cost analysis and show them, how much does it cost to host this data offline for, each month, and how much would it be to have to recollect and reprocess everything.
I was just going to say that the benefit of from like weaponizing that almost from a timing agreement perspective, knowing that you're typically, if you're starting anew de novo each and every time, as opposed to, hey, we have 15 of the 20 custodians for a very large overlap of time. We're not going to have to recollect, reprocess. We could actually start running some TAR now, and we can get very aggressive on the timing agreement. So I would think there would be a strategic benefit for a client that's saying, we just want to get this deal done and through the approval process as quickly as possible. That's right.
Some industries, I think, are more likely to kind of be ripe for cross-matter work. Generic pharmaceuticals that are doing the same types of litigation over and over. They know they're going to have to draw from the same custodians.
Sure.
Again,
especially if it's the same drug and.
Right. And a lot of times, regardless of the drug, at least some of the custodians, will be the same.
It seems like when we're talking about repurposing, work product and that having that kind of cross matter approach, we talk a lot about privilege. We talk a lot about maybe custodians, you don't have to recollect or reuse their data. But, we're seeing, I guess, emerging uses of this in other areas, whether it's even ones that would impact the responsiveness or non-responses of documents. Any thoughts on that or any experience that you've had?
It's hard to repurpose responsive calls since, you're not going to have the exact same matter with the same responsive parameters, but you can definitely identify types of clearly non-responsive documents that a particular client tends to have in their files, and just set those aside in the first instance, and you don't have to kind of reinvent the wheel every time to identify them and set them aside. You know what to expect, and it can be in a fairly automated system.
Sure, and then of course, I agree. Responsiveness often is very particular to the individual matter, but if you happen to land on documents that are tagged as responsive either because they came back responsive to search terms or to TAR, if it's been produced before in a previous litigation or investigation, that would certainly be helpful to know, because you might not have to run a priv review over the top of it, and you could just produce it without QCing it.
That's a good point. Yep.
Yeah. Jason, really, thanks for doing this. We appreciate it. I'm going to try to sum up what we talked about. Generally, I think we touched on a new administration, and while the industry maybe saw a dip, Axinn really didn't last year. You haven't really seen the effects of the new administration yet, but it's going to be interesting to see what happens. And I agree with you, in the next 6 to 12 months, based on their posturing now. In terms of single matter versus reuse, the default is typically single matter, because you're not often in the case where a client has data sitting that would still be relevant to a second matter. If you do get lucky, and I think you said you're just doing that recently. If you do get lucky and you do it, some of the challenges of doing a single matter are costs, obviously, timing, collecting documents anew, working through, especially with a client that's not been through, let's say, an HSR before or a major litigation, the process of collecting documents and teaching them how to do that, processing everything anew, so on and so forth. The pros, on the other hand, of cross matter are not even just recollecting, not having to recollect not having to reprocess. But also I thought something that you mentioned that was particularly interesting. Just the familiarity with that client, their data and how they work. I think especially when you use the same reviewers, there's probably a huge amount of efficiency built into the speed and accuracy of the review when you've worked with clients before. So repurposing work products, certainly not having to recollect, but also just familiarity. I thought that was an interesting point. In terms of Priv, while we do see AI starting to make headway there, it's something that, I think Priv is always just that nuanced piece of work product that takes a little bit longer. So any AI that's sort of helping, we're seeing that advance. And certainly that's going to help with cost and timing, two big things on HSRs, for instance. In terms of workflow and process, if you know that it's coming, if you have the benefit of foresight, like as you said, and it's coming, it makes it a lot easier to sort of to draw that out, because you could sort of be, as you're working on the first, you could sort of be, have in mind how you're going to reuse that in the second. But more often it just sort of happens, and you get to see this when you start to see similar custodians. The same client comes in, you immediately cross-reference in your head the custodians that you deal with. There's so much overlap, obviously, with the deal teams. So you're going to see a lot of the same people, and you wouldn't have to recollect and, essentially mitigating the time and cost associated with doc review, and just having to go and fill in the gaps in anything that's been created in the time period difference. And, in terms of responsiveness, tough to repurpose responsiveness, easier to do Priv, easier to do objectively non-responsive stuff. But we did touch on just that area where you have responsive and has been produced before to avoid maybe a Priv. And I think the last and maybe the most important point is, if you're really looking for career in EDiscovery, don't forget Craigslist, because it could be the difference in whether or not you're happy with your career rather than just having a job. So I think I caught all of that. Jason, really, really appreciate you doing this. Love bringing some really specific use cases around technology, not just talking about it generically. So thanks for doing this.
I appreciate you having me.
Thanks.
All right. Thanks, Jason.
Hey, party people, if you're a big fan of Law and Candor, do me a favor, rate us on wherever you get your podcasts, Apple Podcasts, Stitcher, wherever you get them. Follow us on Twitter at Law and Candor. Subscribe, unsubscribe, resubscribe. Please follow us at Law and Candor on Twitter. Thanks so much.